We're going to begin with that breaking news overnight. A major ruling by a federal judge against former President Trump, rejecting Trump's claim of executive privilege to keep the House committee.
Let me walk you through exactly how it died. Friday afternoon, 2 o'clock, Southern District of New York. The hearing was supposed to be routine. Trump's legal team walked in, still projecting total confidence. 93 minutes later, they walked out with their entire privilege strategy in ashes. Judge Marianne Chen did not raise her voice. She didn't need to. She had a 43-page ruling ready, and she used every page like a scalpel. Paragraph 17 dismantled the executive privilege claims. Paragraph 24 shredded the attorney-client arguments. Paragraph 31 finished off the marital communications privilege. One by one, methodically, surgically, she rejected every single protection Trump's lawyers had spent 8 months and an estimated $3.2 million constructing.
Late today, a New York appeals court judge denied his motion to delay Monday's hush money criminal trial. And apologies for not prefacing that with "stop me if you've heard this before," because you have. Here's the headline from just 2 days ago. Appeals court denies another Trump attempt to delay trial. Again, that was Monday, seeking more time to pursue a change of venue motion. Ditto yesterday, asking for more time to challenge the gag order their client is under. Today, it got even richer, with one Trump attorney arguing for more time to file more defense motions, to which Stephen Wu, arguing for the Manhattan District Attorney's Office, said was simply not the way these things work. We're going to leave that for our legal panel.
At 4:47 p.m., the gavel effectively fell. Defense motion denied in full. Prosecution's discovery request granted completely. $4.7 million in assets suddenly exposed. 127 pages of communications ordered released. 23 witnesses cleared to testify without restriction. The reaction inside the courtroom was almost comical. According to reporters present, Trump's lead counsel sat completely motionless for 11 full seconds after the ruling was read. 11 seconds of pure, stunned silence.
You had defendant Trump sitting there in court as questions were asked about whether, as they put it in court, does Melania know, quote unquote, that he had this affair? Did this happen, quote unquote, during the marriage? Referring to those texts as Keith Davidson, the lawyer for Karen McDougal, spoke to Dylan Howard, the tabloid senior publisher figure, about the nature of this story. So I think this was by far one of the most intense court days for the defendant, and clearly, from my view, just to tell you, in the room, I could see the side of the defendant's face as he kind of watched it. He largely looked composed or even nonplussed at times during what was obviously a striking or dramatic moment. I also had a view of the jury, and while we're careful about not describing them in detail, as a general matter, the jury appeared very attentive, very rapt, very focused on what was a very eventful set of facts or allegations put forward.
The prosecution team, they didn't even smile. They just packed their files like professionals who had expected exactly this outcome. Within 90 minutes, Trump's lawyers filed an emergency appeal. Desperate, frantic, the kind of filing you make when you know the floor just disappeared under your feet. Saturday morning, that appeal was denied, just like that, by 6 p.m. Friday, legal analysts across 7 major networks were already calling it the most significant setback in Trump's criminal defense to date.
Reporting on this Trump defeat at the Supreme Court today. 6 justices striking down these tariffs. It's a clear blow to what we know was a clear and major economic priority for President Trump. The High Court nixing Trump's tariffs. All of this is important and lands as a path to potentially a wider check on the president's efforts to seize emergency powers. That ranges from trade, the subject of this case, to potentially military policing, and a lot more in this MAGA era. This ruling is obviously a setback for Trump. It is the most sweeping rejection of Trump's attempted power grabs from the Supreme Court that we've seen his entire second term.
Cable news ran wall-to-wall coverage. White House counsel scrambled out a statement at 8:15 p.m., claiming they strongly disagree and will pursue all available remedies. As of this morning, none of those remedies have worked. Think about what just happened. 8 months of work, 7 different law firms, millions of dollars. All of it collapsed in a single 93-minute hearing because the documents they swore were the most privileged materials in America had already been sitting in the public record. This wasn't a close call. This wasn't a tough loss. This was a total, humiliating, self-inflicted demolition. And the best part? The people who built this fortress of privilege never even checked whether the walls were already gone. That's the 93-minute collapse. Now let me show you the documents that made it inevitable. Those 93 minutes only finished what the documents had already started. 47 emails, 11 text threads, a stack of financial records covering 14 full months. That is the exact inventory that walked into the public record and never walked back out. These were not vague memos or secondhand summaries. These were primary source materials straight from the private communications between Donald Trump and Melania Trump. Inside those files sat Trump's personal banking instructions, clear directives about where money was supposed to move and when. One transfer stood out immediately: $1.8 million sent to a Delaware limited liability company.
Now, President Trump wasn't clear how he was going to react to these decisions, and it's been a pretty mixed day for him overall at the court, but he described this as, quote, a big win.
I want to bring in our chief Supreme Court analyst, Joan Biskupic, right now. Joan, like Pamela, Paula, you were inside the court when these decisions came down. Give us a little sense of how that felt.
Sure, Wolf. It's good to see you. The most important thing the justices did today was in the case involving Rebecca Slaughter of the Federal Trade Commission. Chief Justice John Roberts and the conservative majority used that decision to roll back nearly a century of legal policy about the president's power to remove the heads of regulatory agencies. Now, in some ways, this is going to sound kind of dry and arcane, but regulatory agencies are so important for how Americans live their lives. They cover rules for, medical, health, nuclear power. In this case, it's the Federal Trade Commission that was at issue, and we're talking about, safeguarding consumer practices, antitrust issues. So that gives you a sense of all that's at stake. But this court, for many, many years, has really not appreciated the congressional power to set these up and set up independent heads that the president can only remove for what's called for cause.
Alongside it were detailed discussions about legal exposure, the timing of certain disclosures, and how particular financial arrangements should be handled if pressure ever arrived. These were not ceremonial talking points, these were operational records. Melania's civil lawsuit needed every one of them. She was suing a former senior advisor for misappropriating funds and leaking private information. Her damages claim sat at $2.3 million. To prove both the existence of the financial arrangements and the scale of the harm, her legal team had to show the court exactly what those arrangements looked like and how they had been violated. There was no cleaner way to do it than by attaching the original communications themselves. Her attorney, Patricia Sanchez, did not act alone. In April, she received direct authorization from Melania. The instruction was blunt and unambiguous. Use whatever proves the case. That single line of approval turned private, marital, and financial records into courtroom exhibits. Once those exhibits were filed on May 28th, they entered the public docket of the Southern District of New York. From that moment forward, they were no longer secret. They were evidence. Here is the exquisite part of the disaster. The very same documents Trump's criminal defense team later swore were shielded by executive privilege and marital communications privilege were already sitting in an open court file. Same courthouse, same federal district, different case number. Melania's lawyers had done exactly what any competent civil litigator would do. They used the strongest evidence available to win their client's case. They had permission, they had strategy. They had no obligation to coordinate with a completely separate criminal defense team that, as we will see, never bothered to look. So when Judge Chen later wrote that the privilege claimed cannot extend to documents the First Lady herself disclosed, she was not inventing new law. She was simply stating the obvious. You cannot demand secrecy for material your own spouse has already placed into the public record with full authorization. The documents did not leak. They were deliberately produced. And once produced, they became the weapon that made the 93-minute collapse inevitable. That is what actually destroyed the defense. Not a mysterious breach, not a rogue staffer. Just a First Lady who decided to win her own lawsuit, and a set of records that were never supposed to see daylight in the first place. The documents were already public. The only remaining mystery is how Trump's entire legal apparatus managed to miss them. Same federal courthouse, same Southern District of New York, different floor. That is the entire geographic distance between Melania's civil case and Trump's criminal case. A basic PACER search, the federal court database, costs 8 cents per page. 8 cents. Maximum charge per document is $3. Nobody ran it. On June 18th, during a routine status conference, Judge Chen looked directly at Trump's lead attorney and asked the simplest possible question. Are you aware of any other proceedings involving these materials? The answer came back clean, confident, and completely false. No, Your Honor. These are uniquely privileged communications. Uniquely privileged. Those were the exact words. 15 days after the same communications had entered the public record, Trump's lawyers stood in open court and declared them uniquely protected. I have read that transcript 4 times. The arrogance is almost impressive. The prosecution had already notified the defense of the overlap on Wednesday evening. Trump's team then spent 17 straight hours trying to invent a distinction that would somehow make publicly filed documents secret again. They failed. Thursday afternoon, they filed a 12-page supplemental brief claiming different legal context means different privilege analysis. The prosecution answered in 4 hours with 8 pages that said, essentially, you cannot claim something is confidential when it is already on the public docket. Judge Chen agreed. This was not a sophisticated intelligence failure. This was not bad luck. This was the most expensive legal team in American politics, refusing to spend 8 cents to check whether the walls of their fortress were still standing. They built the privilege claims. They filed the sweeping motion. They looked the judge in the eye and said the materials were uniquely protected. And the entire time, those materials were sitting 1 floor away, available to anyone with a PACER account and pocket change. That is the fatal blind spot. Not a leak, not a betrayal, just pure, multi-million-dollar negligence dressed up as high constitutional principle. The documents did not destroy the defense by accident. They destroyed it because the people paid to protect the president never bothered to look. To understand why the blind spot was even possible, you have to go all the way back to the beginning before any civil suit, before any criminal charges, before anyone was paying attention. The 28th of January, 2025. 2 weeks after inauguration, Trump filed a required financial disclosure amendment with the Office of Government Ethics, 84 pages. Buried on page 61, under Schedule of Liabilities, sat one quiet line, contingent liability related to ongoing business dispute. Estimated exposure, $2.3 million to $4.7 million pending resolution. Nobody outside a handful of ethics officers and White House counsel even noticed. 2 weeks later, on February 11th, those same people sat down for a planning meeting. Attendees, White House counsel, the chief of staff, and Trump's personal attorney. Topic: potential legal exposures for 2025. The decision they reached was clean, logical, and fatal. The president was advised to maintain completely separate counsel for personal matters. Coordination protocols were supposedly established. The meeting notes, page 3, put it in writing. Separate counsel structures will prevent conflicts and maintain appropriate boundaries. That single sentence became the original sin. They deliberately built a wall between official legal strategy and anything involving the First Lady's personal affairs. Melania would later hire her own private attorney. Trump would later hire his own separate criminal defense team. No shared monitoring, no mandatory cross-check of dockets, no requirement that one side even know what the other was filing. On paper, the idea made sense. Keep the presidency clean. Keep personal litigation at arm's length. In practice, they created 2 parallel legal universes that were never required to speak to each other. 14 months later, those 2 universes collided in the same courthouse, and the wall they were so proud of turned out to have no windows, no doors, and no one standing guard. That February 2025 meeting is the first domino. Everything that followed the independent civil suit, the privilege claims filed in total ignorance, the 93-minute demolition traces straight back to one deliberate choice: separate everything, monitor nothing. Intention, sound. Execution, pure, predictable, multi-million-dollar Trump. Of course, Trump's team has excuses. They always do. Their argument is polished, constitutional, and completely detached from reality. They claim Melania's civil disclosure does not automatically waive executive privilege. Different proceeding, different parties, different legal standards. Presidential communications, they insist, carry unique constitutional protections that survive even when a third party, yes, even a spouse, puts the same material into the public record. Lead attorney Benjamin Kowalski put it this way in the emergency appeal: spousal filing in an unrelated civil matter cannot nullify executive privilege vested in the office. They waive Supreme Court precedent. They invoke separation of powers. They remind everyone that Melania was never the executive Trump was. And they found a Georgetown law professor, Vivian Hartwell, willing to call the whole intersection of marital communications and executive privilege genuinely novel questions. Novel. That is the tell. In normal English, novel means we just got caught and now we need a brand new theory to explain why the ordinary rules should not apply to us. Waiver by disclosure is not novel, it is black-letter law. Once a document is publicly filed in any court by someone with authority to file it, the privilege is gone. Courts do not care that the filing happened in a different case. They do not care that the person who filed it was the president's wife instead of the president. Public is public. The defense wants you to believe that two people can hold the exact same records. One of them can hand those records to a federal judge, and the other can still scream secret in a different courtroom down the hall. That is not constitutional principle. That is magical thinking dressed up in separation of powers clothing. The excuses sound impressive until you remember one simple fact: the documents were already out. Everything else is noise. So what does any of this actually change starting tomorrow morning? 127 documents previously locked behind privilege claims are now moving into discovery. 23 witnesses who were blocked are cleared to testify. Depositions are scheduled to begin July 22nd. The prosecution's timeline just accelerated by 4 to 6 months. A trial that was drifting toward 2027 could now land much earlier. The immediate calendar is brutal. Today, July 14th, the emergency appeal is being heard in the Second Circuit. Thursday, the 16th, is the deadline for the prosecution's updated witness list using the newly available material. First depositions of previously shielded witnesses start the following week. Legal analysts put the odds of a stay at roughly 30% and the odds of a full reversal on the merits at around 15%. In plain English, the ruling is probably going to stand. Now here is why this should matter to you, even if you never set foot in a federal courthouse. What you file in one case can destroy your position in another. If you are married and both of you are in litigation, divorce, business dispute, tax fight, your spouse's lawyer can waive protections you thought were ironclad without ever intending to hurt you. Example: you claim certain financial records are confidential in a tax case. Your spouse files them in a divorce proceeding to prove marital assets. Those records are no longer protected. Same principle, same destruction. Trump's team just paid an estimated $3.2 million to learn that lesson the expensive way. A cheap civil filing fee and one authorized production of documents did more damage than any prosecutor's motion. The uncomfortable truth is simple. Privilege law assumes parties coordinate. In real life, they often don't. And when they don't, the walls come down fast. If you are in any kind of legal fight right now, demand that every lawyer representing your family actually talk to one another. Check the dockets yourself. 8 cents a page is a lot cheaper than watching your entire defense evaporate. The most powerful legal operation in the country just got destroyed by a coordination failure. Your case is not safer. Not a leak. A multi-million-dollar cell phone. I'll break down the appellate decision the second it drops. Subscribe to U.S. Inside Justice for analysis that follows the documents, not the spin. This story's just getting started.